the next very important feature in the operation of judicial precedent is law reporting. For judicial precedent to operate effectively, there must be a full and accurate record of cases and their judgments. Although records of law reports can be traced as far back as the 13th century, these were brief and inaccurate. It wasn't until 1865 that we had a more accurate and a more reliable form of law reporting. Now, two main series of reports are the All England Law Reports and the Weekly Law Reports. The broadsheet papers, such as the Times, the Guardian and the Independent, also have records of law reports, and you can find them weekly, as do legal journals like the New Law Journal and the Law Society Gazette. And I would say to you, as law students, it's worth having a look at cases that are reported in some of those broadsheet newspapers that I've just mentioned. You'll find that the legal journals like the New Law Journal can be found in some of our local libraries, especially some of the university libraries, which you are able to access. Becoming a self-directed learner is a vital step in maximising your own learning and in achieving exam success. Now, in order to be the best learner you can possibly become, it's vital that you cultivate the skills that will help you become a self-directed learner. You'll learn more effectively this way, and you'll learn at an accelerated pace, and you will achieve success sooner rather than later. Now, you've already heard your teachers discuss the importance of managing your own learning, and this means both time and resources. It's also important to effectively note take, and it's also very important that you revisit what you've learned on a regular basis. Make it a weekly thing. Even if it means you pull out your notes and you just skim through them, that's better than not looking at them again, because what you want to do is embed your knowledge into your long-term memory, and the only way to do this is to revisit your notes over and over again. Now, also be able to assess your own learning well, practice past papers, be able to navigate the AQA website, okay, and know where the past papers are and the marking schemes, and get used to sitting down and setting the time for 10 minutes and having a go at some of those questions. Okay, so when you follow the link in the previous slide, it will take you to the AQA website where the past papers and the mark schemes are. Now, you can see that purple bar and it says June 2012. Now, there are a number of years below it, okay, and you'll be able to access papers for perhaps the last 5 years. Now, below June 2012 is Unit 1. Now, in Unit 1, you'll find both the question paper and the mark scheme. Okay, so I've gone into June 2012 and into Unit 1, and I found the Judicial Precedent question, which is questions 10, 11 and 12, and you have to answer 10, 11 and 12, and they are each worth 10 marks. Now, what I would advise you to do is, once you've understood or feel that you understand the key components of precedent, because I want us to focus on question 10 there, which is outline the main features of judicial precedent. And we have discussed the main features of judicial precedent within part 1 and part 2 of this video. With that information, with Law Bank resources, with the resources on Moodle for you, you will be able to set your timer for 10 minutes and, you know, by all means, have all your notes in front of you the first time round and answer that question. Now, in order to assess how well you've done on that question, then go to the mark scheme and have a look at what the examiner would be looking at when he or she is marking your answer. Okay, now this is the relevant mark scheme for that question you've just seen. Outline the main features of precedent, and you can see there that the examiner would be looking for information on the hierarchy of the courts, an outline of the court structure, which courts bind others, which courts are bound by courts, the need for a court hierarchy, what is the ratio decidendi, what is the obiter dicta, the importance of law reporting. Okay, and you can see there it says possible reference to binding precedent stare decisis would enhance the answer. Okay, so a student who is able to get maximum marks would demonstrate a sound understanding of all of the, or most of the points that are listed above. So you can see how useful that is. With that in front of you, you can then assess your own learning and you can see what you were able to cover and what you had forgotten to cover, and then make sure you do it next time round. Okay, so when you're looking at the exam questions and the exam paper itself, you notice that next to each question you've got how much the question is worth, and you notice that 10, 11 and 12 were both worth 10 marks each, but there was also an additional 2 marks for quality of written communication. Now please don't underestimate the importance of quality of written communication, and that's why we're focusing a lot on literacy with more emphasis this year, because it is important that you don't lose those additional marks, but it's important for lots of other reasons, not just purely for the purpose of passing an exam. It is important that you can clearly express your ideas. Now, clear expression of ideas means that your writing should be legible too, and your sentences short, concise, straight to the point. Now, if your writing is difficult to read, how is the examiner going to know that you've covered certain points if he or she can't actually make out what you're trying to say? So it's important that your writing is clear. It's important that you use a good range of specialist terms, so your Latin terms and your legal terminology, and you watch punctuation and spelling.